Good afternoon, everybody. I know it's 12 o'clock. We're going to give a few minutes more to see if more members of the planning commission go. We do have a forum here.
have to be attended there.
It's supposed to be, you're wrong. Kelly,
Yeah.
it's supposed to be on this side. It's supposed to be to our left, your right.
I believe it says,
I just looked it up at the Stone Hatchery that Saturday because you moved it over there. I had a question about it. It's supposed to be on the right for you guys.
Good afternoon, everybody. My name is Cabal. I'm an attorney that represents Green Charter Township. This is the Planning Commission organizational meeting because one of the things the Planning Commission will do at an organizational meeting is appoint officers. Before they get formally organized, there's a chairperson to moderate the meeting. I will serve as, I guess, the meeting moderator until agenda item 6. There should be agendas right by the door over there. If you do not have an agenda, but otherwise, we'll call the meeting to order and start off with the pledge of allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Next up is roll call. Because this is your first meeting, feel free to say maybe a sentence or how long you've been living in the township. We'll start with the roll call. We'll start that first.
Sure. My name is Steve Owen. I've been in Green Township since 99. I've been a registered nurse since 1987. I did a lot of critical care travel nursing, and I live up here on the road in Green Township. I'm not a speaker. Been in Green Township for 30+ years. So I'm retired.
Brent Mason, I essentially lived here for all my life. I moved here when I was 2 years old. And been a paramedic for County for over 20 years, a couple of other in the state, and I'm in the field.
I introduced myself, but I am Kyle Brown, one of the township attorneys. I work at Baby Hills Bridge Road in Oak Michigan.
I'm Larry Finkfire. I've been a resident of Green Charter Township for 6 years now. Semi-retired. Live from home.
Kelly Cushway, resident since 1977. Done a little bit of everything. I'm a retired instructor and semi-retired.
Well, perfect. We have 5. It sounds like based on that, we are missing Robin, Madeline, and Ross Mead. We'll have those mark absent. We do have a forum here. There are 5 members of. All right, approval of the agenda. So this is one that I think you all knew. There is a prepared agenda, proposed agenda in front of you, corresponding with the special meeting notice. If the agenda appears acceptable to any of you, you would make approval. All right. So we have a motion by Larry and support by Brent. All right. All those in favor of approving the agenda?
Aye.
All right.
Okay. Any opposed? All right. Motion carries unanimously. All right. Number 5 on the agenda is approved bylaws of the Planning Commission. So in front of you, you should see a proposed set of bylaws. What I plan on doing is talking through them with all of you. One change that would have to be made, if we go onto page 3, under forum, the word 3 should be changed to 4. So on page 3, number F, forum, that should be 4. Okay. So, a little bit about Planning Commission bylaws. Bylaws are required by Michigan Planning Enabling Act for the transaction of business and to deal with any conflicts of interest that may come before the Planning Commission. You know, the land use application from let's say your wife, well, it doesn't make sense that you should vote on it. Those are the two things that the Michigan Planning and Enabling Act tell planning commissions to do, to adopt bylaws. In front of you, you have a template that is similar to a draft that the Michigan Township Association generally recommends, although there's a few tweaks that our firm has made in this proposal that in some ways, sometimes bylaws can get very strict. They can mention we'll use Robert's Rules of Order. My experience with townships representing them throughout the state is townships don't always know how to do Robert's Rules of Order. Very sophisticated cities, or quote-unquote sophisticated cities may not also not know how to do Robert's Rules of Order, but they may pretend like they do. So that's kind of the gist of it. I want to go through section by section in big broad strokes of what it says, and then stop me if you have questions with respect to what it says. So page 1, section 1, the top here where it says whereas, that basically says that you want to bylaws. Section 1 outlines the officers and members. Under the Michigan Planning and Enabling Act, you have the obligation to have at least 2 officers. They are a chairperson, essentially a moderator of meetings, and help with the agenda, and the secretary. Secretary has the fun job of taking minutes. I take minutes for a Rotary Club every once in a while, and many people do not like to volunteer to be secretary, but that is a very important role. The Planning and Enabling Act also says you can have other officers. So what these bylaws will say is if you want to make other officers, such as the vice chair, you can do so. Officers are appointed to a period of 1-year terms. Going on to page 2, F. Planning and Enabling Act says that planning commission members serve 3-year terms other than your ex officio member, so Mr. Cushman, and his term corresponds with his term on the township board. Because this is a new planning commission, you were all appointed to 1- to 2-year terms to help stagger them so they essentially expire 1/3 at a time. So you're not all having, you don't have an entire planning commission that needs to be reappointed or otherwise changed out. Secretary is responsible for minutes, correspondence received by the township for matters of the planning commission, so we brought to the planning commission. Then the third, notices, township clerk or the designee will help you with notices with respect to the meetings act and or the Michigan zoning enablement or the planning. Page 2, section 2, meetings. Regular meetings, you have an obligation under the Planning and Enabling Act to meet at least 4 times or 4 regular meetings each year, and by resolution you determine those meeting dates. We don't have that on the agenda today, but that's where we need to do that. Going on to page 3, special meetings can be called by the chairperson or 2 other planning commission members. What this says is if the Planning and Enabling Act allows you to do this, but essentially says special meetings can be called in accordance with the Open Meetings Act. There's a little bit of a stricter standard in the Planning and Enabling Act that I think trips some folks up, where you call a meeting, there's 48 hours, you give people notice. This is basically saying you can call in accordance with the Open Meetings Act, which is the notice of the public meetings act.
What is that?
It's 18 hours for a special meeting at least, yes. Posting on the website and posting on the town hall. Public hearings, other notice, if there's notice that's required by the Michigan Zoning Enabling Act or Planning Enabling Act, let's say you have a public hearing, you're required to follow those. Agenda, chairperson will be responsible for the agenda or their designee. So if someone wants to help out the chairperson, they can help. Quorum, 4 members of the planning commission is a quorum to transact business and take official action. Voting, you need a majority vote, casting, public records. Anything you do, this is very important and not necessarily for just the bylaws, anything you do since you are now on the planning commission that is related to your role as a planning commissioner, town's business, is subject to the Freedom of Information Act. So text messages, emails, you have it. There's various exceptions, of course. But just be very mindful of that what you do now, you're a public official, is subject to the Freedom of Information Act when you're acting in the capacity of your position. Page 3, section 3, duties of the Planning Commission. These are all by statute. The biggest one here is what we were directed to by the board on Saturday, is to make recommendations as to the interim zoning ordinance and initial zoning ordinance of Green Charter Township. Other things that you would be responsible for, I mean, potentially review land divisions, although that is case by case, and then perform other duties and responsibilities as requested by the board. So sometimes what you may see, and I do this sometimes in townships, is, township board is really now a planning commission. They may have police power ordinances, like a blight ordinance, and they may say, hey, planning commission, it would be a great idea if you give your thoughts on that. That's not a statutory use, but the township board could ask you to do that if they wanted to, or they wanted to. Section 4, absences, removals, resignations. To be excused, please notify the chairperson of an excused absence. We understand it happens all the time. Members may be removed by the township board for misfeasance, malfeasance, and nonfeasance in office after written charges in the public hearing before the township board. Hopefully that will never happen to any of you. I have not actually personally seen that, but that is the process that was in statute. If a member of the planning commission is not acting appropriately, the township board can have a public hearing about the removal. And then planning commission vacancies are filled by the township supervisor with the approval of the township board. Conflict of interest, very important. So this relates mostly to, let's say you have a building or you have some ability to act on something, and you have a request that may impact you, that were made such an interest that you cannot faithfully perform the duties that you owe to the township. So all planning commission members, township board members, you are fiduciaries of the township. You are supposed to act in the best interest of the township, how you believe they are. There are a few statutes that help give you guidance. There's not a set of rules that everybody tells you how to do this, like some professions. So, for example, lawyers, believe it or not, have a set of rules that tell you to do that. Many people, they doubt that, but they exist. And, but here, for township officials, we have a few statutes and we have some case law. But what this is trying to do is to incorporate all these. So, going down to page 5, I'll tell you what they are. Planning commission member has a business or financial interest in the property involved in a request. Your uncle, perhaps, let's see, uncle would qualify, doesn't qualify. Your brother, let's do that. Your brother wants to build a pole barn, and your brother needs some sort of permission from the planning commission. You shouldn't, the law kind of dictates, hey, we think you may have some sort of personal interest, so you're going to recuse yourself and not participate in the discussion of the vote. Financial interest in neighboring properties, for factual circumstances of the determination of planning commission may impact the members' intents and judgment. So what this essentially means is, let's give a good example. My best friend growing up, I'm very close to my best friend growing up in high school, and he is applying for, some zoning permission for business. And that may not be a conflict of interest under the guidelines or under the bylaws, but I think I'm not going to be impartial to this, and I also don't want to put myself in a lot. So you can, based on your own judgment, recuse yourself as well. 5, rule of necessity. This rarely comes up, although it comes up quite a bit in a community view of the gigantic wind turbine project. It is where everybody has conflict of interest, and what the law says, and this law dates back to the old English common law. It says it's a ridiculous result that the planning commission could not act on a matter. So you all declare conflicts of interest on record and say you'll vote in the best interest of the township and then you participate on the matter. Very rare that comes up, but you need a process to take into that. And then page 6, what this essentially says is if these bylaws conflict with state law will govern. And it also says if you are working on the matter and you are working on a matter and you comply otherwise with state law, but you make a little slip up and you don't hit on the bylaw requirements, it says that you will waive the bylaw requirement because you acted according to state law. It's kind of the intent of the bylaws are really to shape your behavior for transacting business. It's not kind of gotcha. Hey, I noticed. Let's pick on Larry. I noticed Larry didn't. He didn't call the conflict of interest, but otherwise passed me honestly. I mean, that's probably a bad example, but he didn't act strictly in accordance with the bylaws. So those are the bylaws. Any questions with respect to the bylaws?
read through these conflicts of interest just to make sure that they're doing well.
The conflicts of interest, they come from case law, they come from something called the Standards of Conduct Act, for officers and public employees, that is a statutory process. Actually, the statutorily incorporates the rule of necessity. And then, otherwise, I just see
Pretty basic, yeah.
if all of you are comfortable with it, someone can make a motion to adopt the resolution adopting planning commission bylaws. All right, you would have that this from Olin,
I'll second.
Bushwood, all right, and because this is a resolution, we need to do a roll call vote, so I will start with Mr. Bushwood,
Yes.
Pinkfire,
Yes.
Mason,
Yes.
Streeter, and Olin. All right. All right. So next on our agenda is we have selection of officers, which will be nice because then I don't have to moderate the meeting for you. So you need to nominate a chairperson. This can be by voice vote. There are proposed motions to help you in front of you, but you could nominate, someone can nominate a chairperson. I nominate Brett.
Amazing.
All right, so that's Stu Kleiner and 2 seconds. All right, all those in favor?
Aye.
All right, all those opposed? All right, motion carries unanimously. I will turn it over to you, you can talk through it, and then I'll let you all get.
Okay. So it looks like the next item on our agenda is the nomination of a secretary. I think it's good notes. I actually have done that job in the past, so I understand how challenging it can be.
One thing you could do is you could appoint a secretary to have a conversation with the council clerk with respect to helping with their paper. Then it's not out of the chair meeting. All right? You take notes?
We may be able to, just as Mr. Ramirez said, we may be able to get some assistance from the township on that. So, and I'll mention something that was helpful to me as I use the voice recorder.
And for purposes of today,
And then I would just use that for,
for the purposes of,
yeah, so then I would come forward and say,
Keep the
no, they never be part of the record for before. I mean, it can't be a decision. It's a decision to keep the voice record, then that's part of the record. No, that is.
No, you can't.
Very well, that be done, yes. Yeah, these minutes for planning commission are a little more substantial than the minutes for the council.
So let's talk a little bit about minutes. So open meeting act requires me to essentially outline when the meeting, this is bare minimum, when the meeting opens, when it closes, and the report of motions that are passed and I think you all have access to the NCA materials. They can, I think there's sample minutes that we can look at. Whoever may be the officer of this.
I'll second.
All right, Macy, you want to call the vote? All those in favor?
Okay, all those in favor, say aye. Aye. All those opposed? Motion passes.
Okay. There we go. Interim zoning ordinance. So you have been directed by the township board as to the provisions of the recommendation of a interim zoning ordinance. I want to do a couple of different things. One, I want to explain a little bit of you all have interim zoning ordinance and proposed interim zoning ordinance in front of you. I want to do a couple of different things. One, to explain what the concept of an interim zoning ordinance is. Then the second is to talk about the process that the township has used, which I think has been a very, a good process because the township has retained a professional planner. And then talk a little bit about the content of the interim zoning ordinance from a high-level picture. I know you all have the interim zoning ordinance in front of you. You also have been, to my understanding, emailed a copy of the interim zoning ordinance. And as well as there was, what do you call it, the group, the work group, the work group, which may include some of you on the work group, worked with the professional planner, Williams of Works, Andy Moore, with respect to what the provisions of this interim zoning ordinance look like. So the interim zoning ordinance, what the law considers it as, is a stopgap until the adoption of an initial zoning ordinance of a Michigan zoning gateway act. It can be effective for 3 years. It would essentially act and function like the normal zoning ordinance, like some of the other townships, I think we grab township as our own zoning ordinance. Zoning requests, land use requests would come to the planning commission or the zoning administrator, depending on the circumstances. The planning commission's role here is to review and recommend provisions to the township board for approval and adoption, and I know you all have the ordinance. And then the township board will determine what they would like to do with the recommendation. So some overarching concepts about zoning and this interim zoning ordinance. The first is Williams and Works, a professional planning firm in Grand Rapids, has assisted with the interim zoning ordinance. They have proposed a draft proposal. There is a clean copy. There is a red line from the Mecosta County zoning ordinance, which is the model that's based off of, and I think the thought process there was we want the zoning ordinance to be based off of something that people are familiar with, but we also want local control with respect to land use matters. We want Green Charter Township residents being the ones to review land use and planning matters rather than someone who may not be familiar with the community as well. So when we look at the interim zoning ordinance and its content, I think the best way to do this is you have the ordinance in front of you, but for me to talk a little bit about, okay, this is kind of how it works, and then this memorandum that you all have in front of you from Williams and Works explaining the differences and changes that they made to the county zoning ordinances, county zoning ordinance, which was the template that was used. The other thing, though, is the interim zoning ordinance includes the zoning map that was included on the email, and we'll talk about that too. So overarching zoning ordinance concepts, this is going to be zoning 101, a little bit of a crash course. So zoning works by separating areas of the township into districts. So you may have agricultural, you may have residential, you have industrial, and then it lists land uses that are permitted in those districts. So they may be what is called permitted use, and that is essentially I go either to the zoning administrator and just get a permit, I meet all the setbacks, or potentially you go get site plan review, and if it meets all the if it meets the criteria for something in site plan review, which is the planning commission that reviews it for compliance, or is a special land use. And what a special land use does is it is a land use that may be appropriate in a zoning district, but maybe not under all circumstances, because maybe it may be subject to noise or traffic or something that, it may be appropriate here sometimes, but maybe not. So what happens is there's a public hearing that occurs where the public gets to comment on the zoning ordinance, and then you make a decision whether the land use should be, not zoning ordinance, land use should be approved. So with that concept, that is how the zoning ordinance that you have in front of you is structured. And then, thank you so much for copying that. That's super helpful. So that's how it's structured. The land uses are separated by districts. You may have a single family home. And then for purposes of the public, it would be helpful if we could minimize conversations, because I think, it is complicated stuff that they are doing, and we need to make sure that we are able to do that. So there will be a public comment period at the end of the meeting. So when we look at the function, so that's how the functions of the land uses work. So let's say you have someone wants to build a new home, a residence. So in the residential district, that may be a permitted use. It meets the criteria for the setbacks. Let's say the front yard is 50 feet. I'm not doing a specific standard. They go to the zoning district, get a permit, and then they go to whoever's administrative building, they get a permit, and they build a house. That's it. Let's say someone wants to build a big apartment complex in the residential district. And let's say that's a special use. Well, then they would apply for a special use permit. There would be a public hearing scheduled with 15 days mailing notice and 15 days publication notice. Public 300 feet away would be mail notices. They would come to the meeting. They would talk about why they're apartment building. They may not be appropriate for that location. Then you would determine whether they're granted special use permit or not. That's how that's the distinction of how that stuff functions. So, big thing to know, that zoning permit, that's essentially how that functions. Zoning administrator is probably going to be the most important person for administrating your zoning ordinance, because most land uses, farms, homes, someone putting up a full barn, a garage, accessory buildings, what we call them, they're not going to require you to review approval, unless you want to, but then otherwise you'd be living in a town of all and so they administer your zoning ordinance for you. That would be if the township does adopt zoning, the township board adopts zoning, then they would make a determination of who that individual is. Last thing that should be mentioned is zoning board of appeals. So let's say I am applying to put up a pole barn, and I believe I meet my side yard setback, and it's 15 feet, let's just say that. And then the zoning administrator says, well, I was looking at GIS for the satellite imagery, I think that setback's only 14 feet. So zoning board of appeals can do two things there. One, if I think the zoning administrator is wrong, I can appeal his decision to the body that we appoint that town board. Or two, they can grant a variance to allow the deviation from the zoning ordinance to really be certain. So that's a third body. You don't have to worry about it, but that is what happens when there's disputes essentially on basically all the time. So, any questions about how the zoning ordinance works in the general framework that's straightforward? Not very often. I sometimes they don't have DDA appeal for years. If you're in a larger municipality, you're in the city, you may have a lot of you may have a variance request, a couple months or so. But usually, what you're trying to do is you're trying to make your zoning ordinance clear so you don't have those. Yeah. And if you get too many variance requests, what that is a signal is usually we should have been there something's not right. Good question. Any other questions? Okay. So let's go through this memorandum. There was a red line provided to you of what the changes are, that you can see what the changes are from the Costa County zoning ordinance. But we'll go through them now, and we'll just talk a little bit about what the planning consultant made. So one thing that's important, I think there's a few important things in the beginning, is the township has been subject to county zoning for many years, although interestingly enough, I think it was in the late 90s, the township did explore its own zoning, believe it or not. So it's not unprecedented for this to occur. And then also, many charter townships have their own zone.
Green ones up for zoning in the past?
In the past, there's records of zoning.
How long ago was that?
20 years.
Whatever happened.
It's a little bit unclear. So, we got to review more records. Yeah, and I've had a number of meetings where I've been in a number of meetings, so that process is happening sometimes, because it happens. So, when we think about this, the interzoning ordinance is based on the McCosta County Master Plan, which is helpful because we want to be based on some sort of future land use planning, although eventually the planning commission may adopt its own master plan, which would be your own vision of the future of the township. So like what are areas for growth, what are areas for commercial development, what are areas for
That almost sounds like you're afraid that current, what you know. To me, that don't mean a lot, but yes, once you almost have a master plan.
not for anything.
Right. So at some point, we'll.
At some point we want to, so yeah. So when the McCosta County future land use map is also based on the zoning ordinance and the zoning map is based off this, is what the planner said, anymore. And then aside from changes and changing references to McCosta County and Green Charter Township, the following summarize the subsequent changes we made in adapting the county ordinance. In other words, to a form that is suitable for each Green Charter Township. So you'll see a lot of this. I'm not going to go through this line by line. I know you can email this, but we go through Article 2. There's a consolidation of the agricultural districts. County zoning ordinance. You're zoning for the entire county, all the zoning townships of the entire county. You're going to have different characteristics, and it's a bigger area. It may not be appropriate to have multiple agricultural districts in the township of this size. Remove references to R1 because there are no R1 zone properties in the township. So that's a good example where that may be appropriate for the county, but it may not be appropriate for the township because that was zone. Modify special uses, permitted in ag, add planning unit developments, which are essentially areas where you can have open space and sometimes higher densities, or special land use throughout the entire township. And added a subsection that requires special use approval for certain operations in the industrial district. When we look at general provisions, Article 3, not really much to be changed. There's some changes with respect to wind energy and solar, but not much to be changed. New standards for mining, that's been a hot topic for townships that have their own zoning. What's appropriate for basically gravel pits? What's the appropriate process? There's interesting, when we think of gravel pits, especially the state has preempted certain elements of local control with respect to those, so you want to make sure that your government is consistent with the state law requirements. Site plan review, that's minor changes, new language clearly indicate when a site plan review is required. Special land use, procedural language, or 5. Zoning Board of Appeals article was replaced in its entirety for clarity of organization. We can look at that. I have the red line in front of me. I can tell you what was made by the planner in consultation with the working group. Article 7. So what it looks like the planner did in Article 7 is really just comprehensively change the zoning board of appeals section so it comply with missions. I think it's interesting, there are a number of changes in here that are areas where the county zoning ordinance is not uncommon, where it may not wholly comply with the whole law that's changed. And that's common for the zoning ordinance that's been around for a while. If you have I'll give you a great example, signs. So signs prior to 2015 you can regulate them by content. You can say a business sign is subject to these regulations, and a sign, I don't know, government sign is subject to these regulations. What the Supreme Court said in the United States versus Gilbert, I think Gilbert of Arizona, is you can't regulate the content of signs, or you can't regulate signs based on content. You can regulate them based on basically physical characteristics. So you have a lot of zoning ordinances, including very large municipalities, they still have quote-unquote unlawful sign regulations. So that's the kind of stuff that you see happen. So I think your planner has done a nice job with fixing some of that stuff. So that's zoning board of appeals, administration, talks about Banner Farm to include a zoning permit application for Article 8. Some simplified definitions, all businesses, but believe it or not, that is something that is subject to local litigation, municipality, and whatnot. Interesting. Going on to the last page of this memorandum here, modified definition of farm, farm act, and definition of farm operation. It's very important that that change is made. So the Michigan Right to Farm Act can preempt zoning ordinances in certain circumstances. It's essentially when a farmer is operating consistent with the generally accepted agricultural management practices, which are rules set by the Michigan Department of Agriculture and Rural Development that dictate how you can farm. The intent is to protect farmers from, somebody moving in and they want to live like they did in, let's say, Ferndale, they want to move out to, Livingston County next to farmland, and they start to realize, well, there's a bunch of tractors and smells with this farm. I'm going to sue the farmer. The state has put a stop to that. Said, no, you moved here. If they're operating as a normal farmer would, then any zoning, it's not going to modified definition of variance. Again, we talk about variances. Those are essentially when the standards of the zoning ordinance may not be met, dimensional standards. So we're talking about setbacks, height requirements, those types of things may not be met because lot coverage requirements may not be met because, hey, I'm trying to build my home, I got this land from my parents, just got married, and then realized that a lot of it is unknowable because it's a wetland, and we still want our home put here, but we have to be closer to the side yard setback that is permitted because you need land characteristics, and we don't have to create that. Article 10, that was just a reserved area, there's nothing that was relevant there. And then zoning map, so we look at the zoning map, we have the zoning map in front of us. Rezone property in the township from ag to AF, which is agricultural and forest at best. And rezone the two manufactured home parks to MHP. One thing that I failed to mention, and this was actually kind of the change that is similar to of nature is when we talk about change to the law is developed over time to, in some ways, protect manufactured housing. You would see a lot of townships or municipalities, there's sometimes that decided, hey, we don't like mobile homes, so we're going to regulate single-family dwellings, we're going to say they need certain roof pitches so we don't get any manufactured housing. The state said, no, that is not fair, let's not do that, and that's preemptive. That is the interim zoning ordinance, and then you all had it, and you all have it in front of you. I'm happy to answer questions about it. That would be the best way to do it. I'll answer them to the best of my ability. Well, we have, I think there's still better than that as well. Can be modified at any time. Very good point. So interim zoning ordinances, the intent of them is to be a stopgap ordinance while you adopt a regular zoning. So you're not going to get all, I think this is a great model because it works off of a model that has been applied around the township for quite some time. Some communities, they go to a template, and that's the template we're going to use, and there's a lot of kids in there like, hey, we've always allowed pole barns here, and what are you doing? Interim zoning ordinances can be amended pretty easily. The township board makes an amendment, there's no referendum for instance, for zoning ordinance. They can be truly made throughout the language or whatever.
Basically, what we're saying is this is not working.
I wouldn't necessarily call it that. I would call it not temporary ordinance, but not necessarily. People will be covered by it if it's in fact adopted, but it is something that has to about my house.
It's the same thing.
Yeah, it's the same thing.
Any other questions? I know.
Can you get it on sharp, can you explain what happened with the, R1?
My understanding is R1 in the town, so I didn't put together the special plan together, but I read it. R1, my understanding in the Costa County zoning ordinance, there was no R1 in the zoning map of the township. So essentially, because that district had no land in the township, the regulations could just be removed. If there's something that you see, typically when you see an R1 district,
Yeah, and I can sort of answer a little bit of that too, but that, it was called a rural residential district, so it had just slightly different regulations than what our R2 district is, which is the single family residential district. But essentially, all of those same uses are covered in our A forestry district. So the need for that district doesn't really exist. And we didn't have any of those areas in our township to begin with, so just we just remove the language.
And what do you call it? I'm sorry.
Rural residential.
Rural residential.
Yeah, I believe that it's probably in this red line.
yeah, and I have the county zoning ordinance on the computer.
Yeah.
And it doesn't differ from R2 really at all.
No, it doesn't really, except that it had a couple of regulations that were there, and I think, one of them, let's look at maybe quickly our R2. I think one of them might be building with it. Yeah, so building with it, well, it was one. And so already in the ag forestry district, we allow that building. So that was, like I said, 1709, we didn't really need that district because first off, we never had any zoning for that district in our township. And all those uses are already covered in R2, either the ag forestry or R2. So, right, didn't make sense to have something that we didn't need.
And that point's interesting, and at one point, it led me to think about this, and I didn't think about this when I was presenting the zoning ordinance in town. But, so people may be wondering, what happens if the town adopts a new zoning ordinance and my property doesn't comply with it? That's a very good thought. Am I in trouble, or am I unlawful? The answer is no. You would be a lawful non-conforming use. You would be what many people call grandfathered. And then eventually the goal of zoning is to eliminate lawful non-conforming uses, but we were grandfathered until basically the use of the land changing forever, depending on circumstances. So that's a good point. I think that's something that scares people when people are thinking about the zoning, adopting the zoning ordinance or comprehensive change to the zoning ordinances. Well, shoot, is the zoning administrator going to tell them to give me a ticket and say that, this property I've had for 20 years, so it's the same? No. The answer is no.
Unless it wants to go to the township, Paul.
So I noticed we still have 3 commercial districts. Was there any thought at all about possibly combining all of those districts? All of the approved uses available without the district? That's something, yeah, on the planner. If you ever considered that.
The answer, but it does from my, kind of legal perspective, they are all, many times will not have any districts. I see why, there's highway. When you think of C1 versus C2, C1, I wouldn't say is necessarily next to,
Yeah, it's not next to the neighborhood.
So that's something you could think about. It'd be difficult to make a change. I don't recommend necessarily making a apply here, but you could provide for the township board,
you were wondering why they don't combine C2 and C3 as one?
Well, C1 and C2 are the two most likely ones to combine together. An area of C1 is only a half mile long, or not even half
That
mile
part
long.
of like 2 miles?
It's not 19 miles, and it's called neighborhood commercial, and some of the uses in there that are through. It might be more what you expect to see in the village of Terrace as opposed to along 19 mile road that talks about the availability of access by means other than driving. And, if anything along 19 mile road is pretty much, doesn't need to be driven to do so. That's just where I started, that was sort of caught my eye on that.
Where is that little section? Is that
It's,
on the south side of 19 just before the next one?
It's just to the east of 220th Avenue on the south side. So all the uses right now are residential uses.
Right, I don't see any commercial.
Now, there's no commercial there.
But that 32 acres was for sale.
And that's on the north side of the road. That is on C2. So, yeah.
I have a question about the business in Terrace, convenience store and the carpet store. It looks, according to the key, it would be 1 or 2 family residential. Are these too small to show
I
up?
think this map might have gotten modified in error because I believe that there's like a 300-foot depth there that is commercial along the east side of the road.
That's what it was then.
So I think that's the map might guess. She might be sure.
Okay, so we don't need to worry about
Not to put my vision.
having a chance of that.
There is a home that the rail trail is supposed to be commercial.
Yeah, there's a good homes there too, across that road, so you gotta use that for your access to your home.
Right. Yeah, so I mean, it's, yeah, that's right.
What's that? Those are actually,
Right.
Mr. Secretary, do you mind if I address the board very briefly before we go on?
That's up to the chair, and I will say that.
We're gonna hold to our rules and allow public comment when there's on the agenda after that. So, yeah.
Are you looking for us to adopt it?
If you'd like to, there is a resolution we could adopt this. We would, public comment is helpful because there may be comments that, what the process, let's talk about the resolution. Sure. So it's not to adopt this or recommend it. So when we think of this, there's whereas clauses, whereas if the township board, whereas the planning commission submit recommendations to the zoning ordinance, whereas the township board, whereas the planning commission to submit recommendations, whereas the planning commission had access to all materials provided by professional planning consultants relating to work. To assist with developing into the zoning ordinance based off the Cost County zoning ordinance, which includes drafting the ordinance as well as the zoning map and red line. And whereas the planning commission has time sufficient to review the draft of the zoning ordinance and deliberate content issues that what it would do is it would, before presenting its recommendations to the zoning ordinance, the planning commission would submit its recommendations to the zoning ordinance to the Cost County Planning Commission for the purposes of coordinating the zoning ordinances with local units having a common boundary with the township. The second thing you would do is after transmission, the planning commission would submit the recommended zoning ordinance to the township board, recommends its approval and adoption. And then third, the planning commission is authorized to include council for the township clerk to assist with transmission and adoption as well. So, setting it on the day, if you want to comment on this, if there's, I think we do that for you. That is what this resolution trying to review, is the resolution recommending zoning ordinance. There is a desire to do that, so we make a motion to adopt the resolution recommending the zoning ordinance, and you have to vote on that roll call.
And this can be worked on and changed down the road.
Yes, the interim zoning ordinance can be worked on and so you would move, so let's see, we have Poland, would you, the friendly amendment, you're going to leave that, move to, approve resolution recommending the zoning ordinance?
Yes, sir.
Is there a second?
I'll second.
Chair, let's do the
Mr. Rowland?
Yes, sir.
Mr. Reader?
Yes.
Mr. Pinkmeyer?
Yes.
Mr. Christopher?
Yes.
And I vote yes.
Yeah, I would say that many times we do like 24/1, you know.
So I think we have, when we have a previous.
Oh, you do? Yes,
So, yeah, we did a bylaw with one as well. So that was 24.
Does the chairman always vote, or is the chairman saying that?
Chairman is always vote.
Must always vote?
Yes.
Okay.
Let's stay with confidence.
That takes care of all three items there. Mr. Jones?
Yeah, that's another word. Yeah, okay. So the next item on our agenda is public comment.
Typically, other planning commissions that I've attended, they have a public hearing before adopting their.
Yeah, so it's not a question and answer session, but they're really, of course. And what I think would be helpful, if you look at the agenda, so the agenda says any person, and under the open meetings act, planning commission set reasonable rules with respect to public comment. They have done so by approving their agenda. So any person wishing to address the planning commission may speak on the public comment portion, each speaker will have 3 minutes to address the planning commission during the public comment portion, and then individuals will be asked to put in their name or an address. And I think that helps, especially with the minutes that are being taken. If you would first put in their name and address of your comment. And I don't know if someone else does this time.
Kathy Cruz, I'm a board of pioneer. I'm just wondering if there's a legal requirement for a public hearing before this board can approve the resolution with
No.
ordinance.
No, we're not approving it. We're not approving it.
Okay, I was just curious because of the planning boards that I've covered, they always have a public hearing before they make any of these decisions. So I was just curious if that's a legal requirement.
Because of the law regarding interim orders, that is,
Okay, thank you. Appreciate your answering my question.
anybody else?
Is it public comment session?
It is, that's public comment.
That's the sheriff, the insurance, just trying to keep up with what's going on here. It was kind of interesting that we can't hear a short comment prior that was requested by the community. It seemed kind of a little stifling because we don't know what she had to say that may have had anything to do with this. Three commercial districts seems interesting. Brought up the fact of having an apartment complex brought up closer to walking distance to, that sounds like 15-minute city situations where everything's within walking distance in our rural communities, so walking distance is real important to us. We drove through city geographic for all of our suppliers for years. So I'm not interested in seeing Paris, Michigan turn into a 15-minute city where everyone can just walk to the convenience store. I've heard prospects of having what they would call franchises coming through here. We don't want franchises, we want mom-and-pop businesses. I'm also very disturbed by the B&B residential things that they did behind Paris store, because that disrupted a lot of the natural environment, and I think that was a fail on the zoning commission for allowing that. Okay? not be hindered and cut out. Also, you brought up wind and solar. That's a huge concern for this community. It's a huge concern for the state, the country, and the planet. It's not green, they're not farms. They do not serve the environment, they harm the environment. When people are okay, we have a speaker Saturday, ranting to us how we should accept and embrace EVs, turbines, and solar farms. The problem with that is when you're only looking at one source, the mainstream media in particular, and that's all you're watching. This woman was in fear for her grandchildren's future. Well, we're in fear for our grandchildren's future of not having agricultural lifestyle around here anymore. And I feel that we have to stay on top of stopping that kind of thing from coming into our community. I know it's in effort and hurts you already. So that's something that I really want to try to discuss with you guys, because I don't want to see turbines or solar farms in this community. As a matter of fact, we need to rejuvenate what they've already done across the state.
And so typically for public comment on that, we don't, because it's the reason why I do that, and it seems rude, is you don't want to give one person more time than the other. That's kind of unfair.
I understand that.
So,
I just want to make sure that
otherwise we have to go there.
feel free to give me your, and I'll have to show you.
Thank you, everyone. I hope this works out.
Marjorie Steele, 17603 21 Mile Road, Great Rapids, Michigan. I live in Grant Township, although as some of you know, my family does own property in Green Charter Township. What was your name again, sir? I'm sorry. Are you not allowed to respond with what your name is again?
I'm Kyle, where I represent.
Kyle. So what I was going to say, that would have been salient, possibly, you may or may not have found it salient to your decision today, is simply to remind you something that Kyle did not mention, and I'm not aware that your legal team may be aware of, the many legal teams that are involved, that if you're mentioned today, is that one of the big issues that we have with the Costa County Master Plan and zoning ordinance is that it indicates light industrial zoning, but does not explicitly specify light industrial zoning, nor does it make any distinction between heavy and light industrial zoning. Goshen, of course, falls under heavy industrial zoning. Light would rule it out of the equation. In this amendment, if you are copying it from the Costa County Master Plan and ordinances, I strongly encourage you to specify light industrial uses, and if possible, to discourage or to disallow heavy industrial uses. I also encourage you to ensure that zoning ordinances in regards to solar farms or off-site solar farms and utility-scale wind turbines be disallowed as it is legally allowable in the state of Michigan. These are points that I think that you as a working group and as a committee would have maybe come up with and brought up if you were using common sense instead of being led around by the nose by attorneys who have not bothered to figure out what our issues and what our goals are. So I love y'all, I love the work that you're doing. Please pull your heads out of your asses and use some goddamn common sense. Thank you.
And read the zoning master plan.
God damn it, read something. Read.
Any other public comment?
Anybody that can ask a question, any question. I need to do it very well.
I'll entertain a motion to adjourn.
I'll make a motion to adjourn.